My name's Brett. I'm VP of Partnerships at HR Covered, and today we have Anatoly Dvorkin, who's the President and CEO of HRC Law, which is a fantastic law firm, really the only subscription-based company in Canada that helps businesses. And today he's giving a webinar on 20 minutes presentation on terminations. And then at the end, there'll be a Q&A. So again, if you have any questions, just put them in the Q&A bar. I will read them after. So enjoy the 20 minutes. Anatoly, over to you.
Thanks so much, Brett, and welcome to everyone who's joining us today. Thank you so much for taking time out of your day to learn about terminations and how you can protect your organization when you're considering or implementing a termination. So as Brett said, the plan is to do my presentation in 20 minutes and then leave a lot of time for Q&A afterwards. I did not practice my presentation in advance, so I don't know how long it's going to take me, but I will try to stick to that 20-minute mark. And Brett, thank you for the introduction. As Brett said, I am the CEO of HRC Law Professional Corporation. We are we are a law firm that provides employment law advice to employers only. So we do not work with employees whatsoever. And we'll talk a little bit about our model after the presentation. But for now, I want to get right into the meat of the presentation and talk about terminations. And just before we get to that, of course, there is the legal disclaimer that today's presentation is not intended to be legal advice for any specific question or organization. It's a high-level overview, and your obligations on termination will depend on the specific facts applicable to your situation. So make sure that if you have any questions at all, you contact us or contact another qualified employment lawyer. And just be aware that employment law changes really, really quickly, especially these days. There's new cases coming out all the time, which will have an impact on the advice that you should be getting. So whatever your best course of action is today may not actually be your best course of action tomorrow. So with that, let's jump in. Just a really quick intro about me. So I myself am a small business owner. I own two law firms. HRC Law is the law firm that deals, as I said, only with employers, and we provide employment law advice right across the country, except for Quebec. So if you're from Quebec, I apologize, but we are not actually allowed to practice in Quebec because we're not called to the bar of Quebec. There's my contact information there for you. So if you have any follow-up questions and you want to get in touch with me directly, please feel free to send me an email. Email is preferred, but my phone number is there as well. And I look forward to chatting with some of you afterwards. All right, so here's the agenda for today. We're going to talk some definitions because whenever you are learning about a topic, it's important to make sure you understand the definitions, important to understand the terms of art that the presenter is talking about. Then we're going to talk about the importance of written employment contracts with respect to terminations. We're going to talk about wrongful dismissal versus constructive dismissal. There's a lot of confusion around those terms and what those mean and how and why they're different, or if they're different. We're going to talk about statutory obligations on termination versus common law obligations. Then we're going to talk a little bit about just cause and whether it's worth it to allege just cause in any specific situation. And we're going to talk about organizing the termination and worrying about your liability and reputation as an organization. All right, so let's start with those definitions. So the first thing we're going to talk about is you hear the word just cause or fired for cause a lot. So let's figure out what that actually means. So when an employer says that they've let someone go for cause, or there's just cause, it means that they've fired the employee for a reason. Typically, that reason is that the employee did something egregious or has a history of misconduct or a history of poor performance. And the case law has described it, as you can see on the slide, serious misconduct, habitual neglect of duty, incompetence or conduct that's incompatible with the employee's duties, or prejudicial to the employer's business, or willful disobedience to the employer's order in a matter of substance, that justify the summary dismissal of the delinquent employee. The main thing to note here is that it's a high threshold and it's hard to establish. We're going to come back to that a little bit later in the presentation. More definitions. So what does it mean when you hear notice? What does notice mean? So notice literally means giving an employee notice, but notice the word written. So it's really important that the notice is written notice, because otherwise, in Ontario, for example, unless it's written notice, it's not considered notice. So if you just call up your employee and say, hey, we're letting you know that we're going to let you go in 2 weeks, that's not notice. It has to be written notice. And what is it? It's the notice of the employer's intention to let the employee go, to fire the employee. And the minimum notice periods are set out in the relevant employment standards legislation in whatever province you happen to be in. And then there's pay in lieu of notice. So there's typically two ways when you terminate an employee. There's something called working notice, which is the situation on the left of the slide. And then the situation on the right of the slide is when you compensate someone instead of actually giving them the time instead of the working time instead. So what that means is you're going to give them money equivalent to what they would have earned during the applicable notice period. So if in that particular employee situation, the particular notice period is 4 weeks, that means you're going to pay them an equivalent of 4 weeks. But it doesn't just mean payment of the salary, it means continuation of benefits for that period of time and any other compensation that the employee would have earned during that notice period. All right, so here's another one which is really important, severance pay. So you hear most of the time when you're talking about terminations, you hear about severance all the time, and people use the word severance in a variety of different ways. And there is severance, which is referred to in the legislation, and there's the way that people use it colloquially, which is just to talk about the global sum that an employee might get. But in Ontario and for federal employees, severance is actually defined in the legislation. And in Ontario, it's defined as follows. It's when an employee's employment is severed, and essentially it comes to an end. And the obligation to pay severance is only triggered in certain situations. And those situations are, and there's other details involved as well, but these are some of the most important ones, where the employee has worked for the employer for 5 or more years, and the severance occurred because of a permanent discontinuance of all or part of the employer's business at a workplace where the employee is one of 50 or more employees who have had their employment relationship severed within a 6-month period, or simply that the employer has a global payroll of 2.5 million or more. So, for example, let's say you're an employer in Ontario and your global payroll is 2.5 million or more, and you have an employee who's worked with you for 5 or more years. Pursuant to the legislation, not only do you have to give that employee notice or pay in lieu of notice, you also have to give the employee severance pay. Some more definitions for you. So the other terminology you hear a lot is common law damages or common law. So that just simply means judge-made law. So that's as opposed to legislation. So in employment law, you've really got 2 regimes. You've got the legislation and you've got the judge-made law. And it's important to understand which one we're talking about. Damages means monetary compensation for wrongful dismissal, which are established by the court. So damages is not something that you'll find in legislation. And if you settle with someone, that's not considered damages. But when the court makes an order on a wrongful dismissal case or a constructive dismissal case, they're ordering damages to be paid. And that's what that means. So wrongful dismissal is simply when an employer dismisses an employee with insufficient notice or insufficient pay in lieu of notice, or for cause when no cause is found to exist. And then constructive dismissal is another really common term that you're going to hear in the employment space. And it could mean a couple of different things typically. What it means is either the employer is making a a unilateral change to a fundamental term of the employment relationship, So that means, here's an example. You have an employee that works from home, and that's how they started their employment with you. And then all of a sudden, you decide that the employee has to come and work from the office. So that's probably going to be a unilateral change that's fundamental to the term of the employment relationship. And another way that you might find constructive dismissal is when the employer creates or does not prevent a toxic environment from happening in the workplace, which basically that toxic environment then gives the employee very little choice but to resign. In other words, they cannot continue to work in that environment. And of course, this is really, really subjective. What might be toxic to someone might not be toxic to someone else. And so that's hard to really put some parameters around. But typically, it's the kind of thing when you know it when you see it. Everyone understands what it means to be in a toxic environment. And when it gets bad enough that an employee feels that they have no choice but to resign, that's a constructive dismissal. Now, when the courts look at it, they're going to look at it from the perspective of not that specific employee, but they're going to look at it from the perspective of what we in law call the reasonable person. So would a reasonable person have found that the environment is toxic and so toxic that they have to resign? All right, let's move on quickly to the importance of employment contracts. And this, if you sort of take nothing else away from this presentation, this is where I want you to focus, and this is where I want you to really hone in on what I'm saying, because it could save you a lot of money. So from the employer's perspective, a written employment contract is the best way to do two things. One is achieve certainty in the terms of the employment relationship, but two is control potential liabilities. And that's the one I'm going to focus on today because we're talking about terminations. And of course, one of the largest areas of liability for an employer is when they terminate an employee. All right, so for employment contracts to be useful, it must be enforceable and it has to be up to date. And just to give a little bit more detail on what it means for a contract to be enforceable, at the very least, there's got to be an offer and acceptance. So there's got to be an employment offer made by the employer, and it's got to be accepted with no changes by the employee. So if there are changes that are made or requested by the employee, then the employer has to accept those changes in order for there to be a valid contract or an enforceable contract. But if there's negotiation back and forth until the employer and the employee have come to terms on the specific language in the contract, there is no enforceable contract. All right, there's got to be consideration flowing between the parties. So typically in an employment law agreement, the consideration is that the employee gets a job in exchange for signing the contract. But what happens when you're trying to get an existing employee to sign a new contract? Well, in those situations, you've got to give them something called fresh consideration because they already have the job, so that's not going to be considered consideration. So you've got to give them something extra in order for that contract to be enforceable. The contract has to be unambiguous. There's got to be certainty of terms. And in the employment law sphere, it's got to comply with the minimum standards legislation in your specific jurisdiction. All right, moving on. So why are employment contracts so important? I've already sort of hinted at it, but the reason why they're so important is they can help you really control your liability or your costs of termination. So the main reason and the main function of an employment contract in terms of controlling your liability is when you have an enforceable employment contract with valid termination provisions, you're able to limit the employees that you have to minimum standards on termination versus common law. And as we're going to see later on, common law is much more generous. So the idea for an employer is to make sure that they've got a valid employment agreement with their employees that, for the most part, limits them to the minimum standards upon termination. Now, of course, there's going to be some employees in your organization you may not want to do that with. There may be some really key personnel that negotiate something better than that for themselves, and that's fine. But in general, and for most employers and most employees, what you're trying to achieve is the limitation of their rights upon termination to the minimum standards in the legislation. Another way to limit your liability, and this really came to light during the COVID pandemic, is, during the COVID pandemic, people were being laid off left, right, and center because, employers had to close down. And the legislation typically provides for employers to lay off their employees on a temporary basis. However, the common law comes in and says, hold on a second, you can't actually do that without it being considered a termination unless there's a clause in the contract where the employee has agreed that a temporary layoff does not amount to a termination. So another really important thing to consider. And then also upon termination, it allows you to have clarity around bonuses on termination. So that's a very often disputed term. So if an employee has been getting bonuses for several years in a row, and then they're terminated, let's say, before the bonus is paid, so there's questions surrounding, well, should the bonus be part of their severance package? Are they entitled to that bonus upon termination? So having very clear terminology in your employment agreement surrounding bonuses is also really important. All right, so let's talk a little bit about wrongful dismissal now. So wrongful dismissal, and this is what happens, typically when an employee gets dismissed and then they go see an employment lawyer who deals with employees, and the employment lawyer is going to give them advice. And the advice they might give them is, they might say to them, hey, you've been wrongfully dismissed, you have a case against your employer. So let's look at what that means. So wrongful dismissal occurs when the employer dismisses an employee and alleges cause, so alleges just cause, but there is no cause, or it is determined that the employer did not have sufficient cause. And the other way you're going to have wrongful dismissal is when an employer terminates an employee and fails to provide the employee with sufficient notice or pay in lieu of notice under the Employment Standards Act or the common law. All right, so now that we've talked about wrongful dismissal, let's talk about constructive dismissal, which is very similar to wrongful dismissal. But a constructive dismissal is basically, and we've talked a little bit about this before, but the definition that you find in the case law is that the employer's conduct demonstrates an intention to no longer be bound by the employment contract. And the courts have taken a flexible approach in determining whether an employer's conduct evinced an intention to no longer be bound by the contract. So two approaches have emerged. First approach is that the court has identified an express or implied term that has been breached, and then determines whether the breach was sufficiently serious to constitute constructive dismissal. And then the second approach is more so when we talked about the toxic environment. So that's where the court considers whether the employer's conduct more generally shows that the employer intended not to be bound by the contract. And here's just a little quote from a case that says that the second approach requires consideration of the cumulative effect of past acts by the employer and the determination of whether those acts evinced an intention to no longer be bound by the contract. And so again, if an employee finds themselves in a situation where they have a manager who's constantly harassing them, screaming at them, maybe even there's violence in the workplace or something like that, and the employer's not doing anything to stop that, that's going to be a constructive dismissal. And that's the second sort of approach, where it's not a specific breach of the employment agreement. It's not a fundamental change to the terms of the agreement, but what it is a clear indication that the employer is not carrying out its duty to the employee in such that the employee can consider the employment relationship to be at an end. All right, so now, really quickly, now that we've got a lot of the definitions straight, let's look at employer obligations, because this is probably what you've come to learn about. What are your obligations when you terminate an employee? So there's a bit of a flow chart to look at here. So first of all, there's an overlooked question a lot of the time. It's a threshold question. So is the worker an employee? Now that seems like a strange question, because why would you be worrying about this if the worker's not an employee? So oftentimes employers have not only employees who do work for them, but they have contractors. So you might have a number of people that do work for the organization, and those people might not actually be employees. They might be doing work as contractors. Then you got to determine, are they dependent contractors or are they independent contractors? So if they're a dependent contractor, then the employer has obligations upon termination towards the employee. If they're an independent contractor, then they do not have any obligations to the worker, aside from laws which generally apply to protect people and businesses. All right, so now let's look at continue looking at employers' obligations. So we want to talk about, does an employer need a reason to let an employee go? And the answer to that is no. And this is a huge misconception I find when we're talking to people. They often want to talk about the reason that they're going to let someone go. And the truth is, you don't have to have a reason. What you have to do is you have to comply with the law. And what that typically means is giving the employee enough notice or pay in lieu of notice. So you could have no reason whatsoever. You simply decide you no longer want that person employed with your organization. So you give them the right amount of notice, you give them the right amount of pay in lieu of notice, and you're good. However, be careful, because if you do give a reason, and often employers do this because they want to justify why they're letting someone go, that reason's got to be legal. And what that means is you can't fire someone for grounds protected by the Ontario Human Rights Code if you're in Ontario, or similar legislation in other provinces. So human rights codes, they protect people from being discriminated against on the basis of things like age, ancestry, color, race, citizenship, ethnic origin, et cetera, et cetera. So if you have a reason, you got to make sure that it's not a reason that's discriminatory on these grounds or similar grounds. So now, once you've gotten that far, you've decided to let someone go, you got to figure out your obligations. So you've got to conduct an analysis. First thing is, are you letting this person go for cause? Do you think you have cause? But remember, cause is a very high threshold. So be sure to check with an employment lawyer. Honestly, it's my opinion that anytime you're going to let an employee go for cause, you should be checking with an employment lawyer whether or not there is actually cause in that situation. And not only is there cause in that situation, but is it even worth it to allege cause? And I'm going to talk a little bit more about that shortly. Okay, so here are obligations. If an employer truly has cause, then many people, including some lawyers, think the employee is not entitled to anything. That is completely false. Do not fall into that line of thinking. It's not true. The employee is still entitled to Employment Standard Act minimums. Okay, so in Ontario, though, in the legislation, there's a higher level, if you want to call a higher threshold of cause. So if the employee is guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer, and the employer is able to establish all these elements, then the employee gets nothing on termination. Although even when I say nothing, what I mean is they're not entitled to notice, they're not entitled to pay in lieu of notice, they're not entitled to severance. But the employee is always entitled to any outstanding salary and vacation paid to the date of dismissal. So don't forget that. All right, but what happens if you fire an employee for cause, but it does not amount to that higher threshold of willful misconduct that's set out in the Employment Standards Act? In that case, don't forget that just because you allege cause, it doesn't mean that the employee is not entitled to their legislated minimums. They're still entitled to notice or pay in lieu of notice in accordance with the Employment Standards Act, which is 1 week for each year of service up to a maximum of 8 weeks. And here I'm talking about the Ontario legislation. They're still entitled to severance pay under the Employment Standards Act in Ontario. However, there's no damages under the common law. unless, of course, the employee takes the employer to court and the court finds that the employer was wrong and there is no cause. So it is a risky proposition to let people go for cause. All right, here's a bit of a flow chart that you can look at. So we're going to say, now what happens if an employer does not allege cause? Then the next question you're going to look at is there a written employment agreement? If not, we know right away that the employee is entitled to common law damages. Okay. So remember earlier in the presentation, I was talking about the importance of an employment agreement and how it can help you really limit your liability. Well, here we see that if you don't have a written employment agreement, then you know right away you're in for common law damages. Okay. If there is a written employment agreement, does it have a termination clause? Again, if not, the employee is entitled to common law damages. So I've seen employment agreements that don't actually talk about what happens on termination. In those situations, you're right back to common law damages. And then finally, if there is a written employment agreement and if there are termination clauses in that agreement, we got to figure out, is the termination clause valid? And if not, again, the employee is still entitled to common law damages. But if it is valid, then the employer's obligations are contractual in nature or determined by the Employment Standards Act. So you're either paying notice or you're either giving notice or pay in lieu of notice in accordance with the Employment Standards Act or in accordance with the contract. And the reason why I say in accordance with the contract is some people have contracts where the contract actually is more generous than the minimum standards set out in the Employment Standards Act, but less generous than the common law. In those situations, you're still able to pay the employee in accordance with the contract. All right, so now let's talk about common law damages. So let's say you're in that situation where you must pay common law damages. How do you figure that out? Well, it's unlike the Employment Standards Act. There's no formula. It's not a mathematical calculation. We do know it's more generous than the legislated minimums. And now there's AI, and there's actually been AI for quite some time that can predict the outcome very accurately. So there's severance calculators out there, and those are fairly accurate. Lawyers have the availability to use some proprietary software, which is more accurate than what's sort of available online to the general public. So if someone comes to me and says, hey, what am I going to owe for common law damages? I literally can put in all the relevant factors and get a very detailed report of what the outcome really should be. And those reports are quite accurate. And the analysis is really based on previous case law, previous decisions that the courts have made. And there was a case called the Bardell decision. And in the Bardell decision, the court set out a whole bunch of factors that they're going to consider to determine how much an employee is entitled to for common law damages. And those factors are things like the length of service. You see, I've bolded that one because that tends to be one of the most important ones. Then you've got the age of the employee, availability of similar employment, as well as any other factors peculiar to that case. So there's lots of factors. It's not a closed off list. The courts can consider many different factors. So now I want to talk a little bit about, well, so is it worth it? Is just cause worth is it worth it for an employer to say, hey, we have cause, like this employee has really done some bad things. They've been a really bad employee. We have lots of documentary evidence in their personnel file that shows that they've been a bad employee. We'd like to fire them for cause. Because in that situation, all we got to do is we got to just pay them the minimums. We don't have to pay them the common law damages. And my answer is this: it's rarely worth it, because when you fire someone for cause, you're essentially inviting them to go see a lawyer and have that lawyer make a determination of whether or not there is just cause in that situation. And oftentimes, you're going to get a demand letter from a lawyer saying that there was no cause. And then you've got to deal with that. So instead, the better approach is ensure that there's a valid and well-drafted employment agreement in place, which limits employees to minimum standards. And then when you go to terminate an employee, you offer them slightly more than the minimum requirement in exchange for a full and final release. So let's just say that you have an employee, you've got a really good employment agreement in place that limits them to the minimum standards. So then what you do, and what I often suggest to our clients is, all right, so the minimum standard is 1 week for every year of service. So what you're going to do is you're going to offer them maybe an extra 1 or 2 weeks on top of that. And why are we doing that? Well, we're doing that because in exchange for that extra payment, we're going to ask the employee to sign a release. And by signing that release, what we do is we buy our clients certainty that that employee is not going to go to a lawyer and try to start a lawsuit against the employer. So now you know that there's nothing else coming down the pipe. We have now have a certain result, and I think that's a really, really good thing for employers. So what are some of the exceptions? So sometimes you're going to have some really egregious conduct. You're going to have theft. Theft is almost always considered to be to substantiate just cause. Violence, same thing. Harassment, same thing. Sometimes it's going to be specific conduct that was prohibited by the employment agreement. So there might be clauses in the employment agreement that prohibit an employee from doing some very specific things, and that say that, hey, we're going to consider that to be just cause if you breach those terms of the agreement. But before you put any of those types of things into your employment agreement, be very, very careful. Always have that checked out by an employment lawyer, because some of those won't fly. And sometimes for an employer, the reason why you're going to allege just cause is because you want to set a precedent for your workforce, that if there's certain conduct that employees are engaging in, you're not going to stand for it. And you realize that it might cost you more financially, but you want to set some ground rules. So the precedent of the situation is more important than the financial liability. All right, and I'm coming to the end here, and soon we're going to take questions. So just a few notes about organizing the termination. So when you're organizing the termination, you got to think about two things. You got to think about protecting your financial liability, and you got to think about your reputation and workplace morale. So those are all really important factors to think about. So some of the tips that we have are that once you've decided to let an employee go, do it quickly. If there's any questions whatsoever about how to do it, what you're going to owe, consult with a lawyer. Never allege cause unless you really intend to rely on it. Something that we've seen over and over again is we have seen employers get themselves into more trouble by alleging cause when they don't really think that there is cause, because they're trying to scare their employee, and they're trying to say, hey, if you come after us, we have all these reasons why there might be cause. But then when it comes down to it and there's a court case, they say, you know what, we're not going to go with cause. So don't allege cause unless you really intend to rely on it. Be forthright when you're letting someone go. And that doesn't necessarily mean giving them a reason for letting them go. It just means, don't lie to the employee. You don't have to tell them a reason, but if you're going to tell them a reason, have it be the real reason, and make sure the reason is not one of those reasons that you're not allowed to fire someone for. You'll always want to allow time for the employee to consult with a lawyer before you insist upon getting a signed release back. So if you give someone a termination letter and you ask them to sign a release in exchange for that extra week or extra couple weeks, you want to make sure that you give that employee time to consult with a lawyer. And the reason for that is if you force them to sign on the spot, or if you say, hey, you have 1 or 2 days to sign, otherwise this is void and you're going to get nothing, well, that employee is going to be able to go to court and they're going to have a pretty good case. All right. And here's a really important one. If possible, you want to provide a reference letter. Now, the reference letter doesn't have to be glowing. You're obviously letting the person go. So there may not be, it may be that you love the employee, but you just don't have a job for them anymore, in which case you can provide a glowing reference letter. But even where you can't, you can really factually just lay out that, hey, the employee worked for us from this, from this time to this time, this is what they did. And the reason why you're doing that is because a reference letter is going to help the employee find another job. And that is always in your favor, because the quicker the employee finds another job, the lower your liability. So those are the tips I have for organizing your termination. And we have now reached the conclusion of the monologue, and now we're going to take some questions.
Awesome. That was very interesting. So let's jump into the questions. Just quickly before I forget, this is being recorded and this will be sent out to everyone after. And if you do want to learn about, if you're not a client already, want to learn about the services, you can reply to that email. We'll get into that a bit more at the end. So let's jump into the questions here. Okay. We had our employment contracts drafted by an employment lawyer within the last year. How often should we review those contracts moving forward?
Yeah, that's a great question. My advice would be there's no sort of formula to apply, but my advice would be have them reviewed at minimum once a year, and I would say, if possible, twice a year. And the reason I'm saying it sounds like a lot, but the reason I'm saying that is we now see, and there was just a recent case that came out like literally last week, which probably has invalidated almost everyone's employment contract in Ontario. Really, really fast moving, dynamic area of law. And what happens is every time an employee is let go and they bring a case to court, courts are bending over backwards to find ways to invalidate employment contracts. So they're finding language that they think offends the legislation, and they're using that. And the creative, plaintiffs lawyers are really good at this. They're saying, hey, you see this language? That language is contrary to the legislation. And because of that, the whole contract should be unenforceable. And so we find that there's probably at least 2 or 3 decisions a year that come down from the courts that require a complete rewrite of the employment contract, which is super annoying, I think, for employers, because it seems like you can never really get in front of this. And the only real way of doing it and protecting yourselves is to constantly be reviewing them and rewriting them as the courts come out with new decisions.
So based on that question or that statement, if you do need to amend the contract or you haven't amended the contract for a long time, how do you get your current employees to, take the amendment or take the new contract?
Yeah, really, really good question. Because oftentimes what you're doing with your existing employees, and I kind of alluded to this during the presentation, is your existing employees most likely will have a written agreement already. Hopefully they have a written agreement already. And so you're going to be presenting them with a new one. And the only reason you're doing that is to protect yourself. And by protecting yourself, you're probably taking something away from your employee. Employees aren't going to be thrilled to sign a new agreement for the most part when there's nothing really of value being given to them. And all you're doing is sort of curtailing their entitlements on termination. However, it's really important to still do it when there's a reason to do it. And the way you do it is you offer them consideration in return. And so the trouble might be that, hey, you might have a lot of employees in the same situation, and it might actually be really expensive for the organization to go and do this. And by that, I mean, if you're going to offer fresh consideration to every employee you need to give a new contract to, that could be expensive. So what I would often recommend is you want to start with the employees who are your longest serving employees, which represent your largest liability upon termination. So you start with those and you work your way down the list. And when you do it, as I said, you got to make sure you're giving them fresh consideration. If you have any questions about whether or not the consideration that you're thinking of offering is sufficient, speak to a lawyer about that, because that's a case-by-case situation, and courts are actually looking at that more closely as well. So there have been there's recent case law where an employer tried to get an employee to sign a new employment agreement and gave them consideration. It used to be okay that you could say to an employee, here's a $10 signing bonus, and that was considered consideration. Now the courts are saying, hold on a minute, you're asking an employee to sign a contract that's going to take something significant away from them. This $10 in return is not enough. So it's got to be something that is actually valuable. Courts are looking closer and closer at that. So do recommend, if you're thinking about doing that, you got to speak to employment lawyers about that as well.
Excellent. We are a small business and we have very little turnover, and we never have had an employee challenge us on termination. Do we really need to invest in new contracts?
But yeah, simple answer to that one, I would say yes. And the reason is all it takes is one. So, you're a small employer. I don't know what your finances are, but let's just assume for the sake of argument that, one significant case can cause you a lot of problems. So you want to prevent that. And it's better to spend a little bit of money on a good contract that'll help you prevent massive liability. Even though you've never had it in the past, that's not an indication you won't have it in the future. So you can't rely on this idea that, hey, everyone's been happy with us. All it takes is one situation, and you might be in big trouble. So my answer to that is a definite yes. Invest in a good employment contract.
We have a bad employee who we were going to get ready to fire, but the employee went on medical leave. We don't want the employee to return. Can we let him go when he is on leave?
Yeah, really great question. And it's something that's a question we field all the time. And these protected leaves, medical being one of them, are really difficult to navigate, especially with employees that you'd like to terminate. The answer is no, you cannot terminate an employee while they're on a protected leave. And I'd go a little bit further even. When they come back from that leave, I would say it's a bad idea to terminate that employee right away. So you want to create as much space and time between the return and the termination as you possibly can. Now, sometimes you can't. Sometimes the employee is just that bad and you have to get rid of them as soon as they're back. In which case, just make sure to, consult with a lawyer, figure out if you can do it for cause. Probably my advice would be don't do it for cause. Just pay them what they're owed, give them enough notice if you can keep them around for that amount of time. But yeah, never ever terminate an employee while they're on leave.
Okay. Why is there such a disparity between ESA termination entitlement and entitlements under common law?
Yeah, really good question. It really this disparity really makes it difficult for employers because they don't know what they're gonna be in for when they terminate someone. Because sometimes they think they're going to be paying pursuant to the legislation, and it turns out that their agreement wasn't good enough, and the agreement gets attacked in court and gets invalidated. Now they're in for common law damages. So why is there such a disparity? The reason is the legislated minimums, and that's the key word there, are minimums. So that means you cannot give less notice, you cannot give less pay in lieu of notice, but you can certainly give more. And the courts have said, hey, those legislated minimums, they're not enough. Because when the courts look at it, they look at all those factors that I was mentioning earlier during my presentation, and they say, based on all these factors, this is how long we think it's reasonable for this employee to find another job that gives them sort of similar, that's of a similar nature, has a similar salary, similar function, similar duties, similar seniority. So they look at all these factors and they say, those 4 weeks that the ESA says, that's not really enough. It's not reasonable that this employee is going to find a job in 4 weeks that was like the job that they had. So we think really it should be 6 months. And so that's why you have the disparity, because when you're looking at the legislation, those are minimums, and the courts look at it, they say, yeah, that's the minimum. You can't go below that, but we can certainly go higher.
So it can often be a lot more expensive than the employer thinks it's going to be.
Absolutely. Absolutely. And that's why I was harping on the employment contract, because and making sure that you have a valid one that's enforceable with up-to-date termination clauses, it could make all the difference. It could literally be, and I'm not exaggerating, I've seen cases where the difference would have been in the hundreds of thousands of dollars.
All right. Okay. Lots of questions still to go. So let's see if we can get through them all. What can invalidate a clause that limits employee entitlement to ESA only at termination?
Not necessarily sure if I understand that question, but there are a variety of things that can invalidate an employment agreement, an employment agreement's termination clauses. So often what we're looking at is does the language, and really this is the crux of the matter, does the language offend the legislation in any way? So what's provided in the contract even less than what the ESA says it has to be? That's one really easy, like absolutely that's gone. So, if the ESA says that an employee is entitled to 1 week for every year of service, and your contract says you're going to get half a week for every year of service, well, your contract is garbage. It's not going to work. But that's a really simple one. You've got other things where the most recent decision I'll talk about, because that's fresh in my mind. Last week, a decision comes down that says an employment contract's unenforceable. So why was it unenforceable? Reason was the contract contained language that said that the employer can terminate the employee's employment at any time. The words "at any time" were enough to invalidate the agreement. Now, this is new. This was not previously considered contrary to the legislation. The courts hadn't considered that language before, and so it's that language is in most employment contracts. So, because you would think that, yeah, an employer can terminate an employee's employment at any time in their sole discretion. Truth is, that's not the case. And the reason that's not the case is there are times, and I just talked about one of those, where you can't terminate an employee. If an employee's on a protected leave of absence, as an employer, you can't terminate the employee. So there's one example, and the court said, well, here's your example. That language is wrong pursuant to legislation. Therefore, the entire contract is void and unenforceable. And sorry, employer, you thought you had a good contract, but now you're paying common law.
Okay. Is there a rule of thumb when determining how many weeks to offer in exchange for a signed release?
I wouldn't say there's a rule of thumb, but the idea that I like to think about is it's got to be, you don't want to break the bank on it because the whole point is you're trying to limit yourself to the minimums, but it's got to be enough to motivate the employee to sign that release. So often, it depends what the entitlement is to begin with. So if the entitlement is 8 weeks, for example, you might say, okay, well, we're going to give you another 3 weeks on top of that. So totally, you're going to get 11 weeks. Those 3 extra weeks might make a meaningful difference to the employee. If it's the situation where it's a really short service employee and they've only been around for 1 year, they're only getting 1 week. Well, if you double it by give them another week, that's probably enough too. So I would say it depends, but the idea to sort of think about is make it meaningful without breaking the bank.
Good advice. Does the ESA standards apply to employees in other provinces who work for an organization that are headquartered in Ontario? No, these out-of-province employees do not work in those provinces as well. So would it be the employment standard laws in their province?
I don't know if I followed that question exactly, but I'm going to try to answer it the way I understand it. And if there's a clarification, let me know. So typically, the situation is, and we had a whole webinar on this, so that's a really good question. So maybe we can even, I don't know if we know who the person is who's asking this question, but maybe we can even send them this recording because it's a big topic. But the sort of long and short of it is where the employee is located tends to determine which legislation applies. So, the employer might be in Ontario, employees in BC. The employee is probably subject to the BC legislation as opposed to the Ontario legislation, if that answers the question.
Yeah, I think that's what they were after. So thanks. For existing employees, if their status changes from hourly to, say, becoming a manager, that's salary, does that mean that a new contract has to be signed that would reflect any eligibility for overtime or no overtime? If yes, do we do considerations?
Yes and yes. Yeah. So yeah, you want to, anytime an employee is changing positions, especially sort of a substantial change, into management, that's an opportune time to give them a new contract. Now, it might be that the consideration is the promotion. So the promotion can be enough to be consideration. That promotion may not only be in the form of title, but also salary. So, or vacation time. So there are a number of ways where you might have built-in consideration in that scenario. If you don't, if the salary is sort of staying the same, vacation time staying the same, and all that's changing is the title, that may not be enough, and you may want to offer a signing bonus or extra vacation time or something like that of additional value.
So quickly, because we got lots to go through, what's the main difference between a dependent contractor and an independent contractor?
Really great question. I didn't have time to delve into that in the presentation itself, but the main difference is a dependent contractor gets most or all of its work from one employer, whereas an independent contractor is essentially, think of someone who's in business for themselves, and they offer their services to a number of employers, and they have the opportunity to decide whether or not they're going to take on that work, not take on that work. So they're more in control of their own work, whereas a dependent contractor is really dependent, as the name suggests, on one employer. In which case they're kind of a hybrid because they're not necessarily an employee because of the way that the employment relationship is structured with that person, but they have a lot of the same characteristics because they're really dependent on that one employer for all of their work and business.
After agreeing and receiving the 30-day notice, if the contractor creates toxicity in the workplace, what rights do the owner have? Can they end the 30-day working notice before? What are the possible repercussions?
Okay, so I'm just going to try to restate that so make sure I kind of understand it. It sounds to me like we're talking about an independent contractor situation as opposed to an employee to begin with. So right away, the first thing you're going to look at in that situation is you're going to kind of throw like the legislation that we've been talking about out the window, because that's not going to be applicable necessarily. But the really first thing you're going to look at is this person truly an independent contractor? That's kind of the threshold question. A lot of times, employers will mischaracterize workers as independent contractors, when in reality, even if the agreement says they're an independent contractor, in reality, if a court reviewed the facts, they would find that the worker's actually an employee. So you got to be careful right there at the threshold level, making that determination. Probably worthwhile speaking to a lawyer about that. Now, let's just assume that it is an independent contractor and you've given them notice, hopefully pursuant to the contract that says, in this case, 30 days. Now, that independent contractor, as I understand it's creating a problem in the workplace, creating a toxic environment. So it does create a duty for the employer to do something about it. And it may be that they have to pull the plug on that independent contractor before the end of those 30 days, in which case you do have to look at the contract to see how are you going to do that? Is there a provision in the contract that allows you to do that? What are the consequences of doing that? Typically, when you fire, and this is kind of similar to a fixed term employee. Typically, when you fire, a contractor or a fixed term employee, you look at the contract and you say, well, this contract says that they were going to have, let's say, until June 30th, 2024, but I'm letting them go, on May 30th, 2024. So there's damages that are created there pursuant to the contract. And then we have to go and look at the contract to say, well, what if the contractor is engaging in certain behavior? Now, as the employer, so to speak, am I entitled to terminate the contract early without incurring damages? So really the answer is you gotta look at the contract to see what it allows you to do and not do, because it's a contractual question at that point. And that's a really, really, in that situation is one where I strongly suggest take your specific situation and speak to an employment lawyer about it.
Okay, we have 5 minutes here. We have lots of questions still. Am I allowed to terminate an employee for no cause by giving them 2 weeks notice, even if they are bringing forward a claim through ESA?
Okay, you're allowed to terminate an employee without cause. The 2 weeks notice, that completely depends on how long the employee's been working with you and the contract that they may or may not have. That last part of the question, it sounds to me like the employee has already brought a claim against the employer, maybe through the Ministry of Labor, in which case the employer has to be careful that the termination isn't considered to be a reprisal for that claim, because that is not something you're allowed to do. So that's a really great question, and it's got a lot of facts around it. I can't answer that one generally, other than to say you got to be careful to make sure it's not a reprisal. And that 2 weeks is not, 2 weeks really just depends. That's not a rule of thumb or anything. You've got to make sure that the weeks match up with the legislation, and that the employee is not actually entitled to common law. So that's I'm going to say that really just depends on all the facts.
Is a full and final release protection against any future claims for wrongful or constructive dismissal?
Yeah, it is, and that's exactly why you want to get one. So long as you've obtained that full and final release in a proper way, meaning there's been no coercion, you haven't threatened the employee, you've given the employee time to consult with a lawyer, the employee has signed that full and final release and returned it, and you've abided by the terms of that full and final release as the employer by giving them that extra consideration for which they signed that release, then I'm going to say, yeah, that's your protection. So if they do start a claim, you're going to go to court and you're going to defend on the basis that you have a full and final release, and